Welcome to the debate. Tonight, we are opening a file that sits at the increasingly blurry intersection of effective policing and constitutional overreach. We're looking at a winter night in Clinton County, Pennsylvania, January 7th, 2023. A traffic stop that began with a simple turn signal violation and, well, ended with a major felony drug bust. We're talking 136 grams of methamphetamine, cocaine, thousands of dollars in cash. But the path from that turn signal to the jail cell is paved with what the courts call procedural anomalies and what the defense, frankly, calls outright fabrication.
Fabrication is maybe the polite word for it. We're dissecting Commonwealth versus Ernest Paul Coit. And look, this case isn't just about whether a man had drugs in his car. The physical evidence strongly suggests he did. This is about whether a police officer can write a work of fiction in a sworn affidavit to cover up a Fourth Amendment violation, and then get on the stand and claim he was just doing his best with old notes when his own body camera footage contradicts him.
That is the flashpoint, certainly. But the broader question we're grappling with here is the legal doctrine of the totality of the circumstances. Does the chaotic, fluid reality of police work, nervous suspects, changing stories, signs of driver impairment, does that justify a detention that stretches over an hour? Or does the Constitution demand that the moment the traffic mission is over, those citizens have to be free to leave?
It's the classic tension, isn't it? Can the ends, and let's be honest, getting a significant amount of meth off the street is a good end, but can that justify the means if those means involve holding a passenger hostage on the side of the road without probable cause? I'm approaching this from the civil liberties perspective, and I have to say, the timeline here it's terrifying.
And I'll be taking the position of the Commonwealth and law enforcement. I'm going to argue that Trooper Joshua Eichenlaub's actions, while, yes, legally messy on paper, were justified by the evolving situation on the ground. This wasn't just a normal traffic stop. This was criminal interdiction in action.
Then let's look at that interdiction, because when you start to peel back the layers, the justification for holding this man gets thinner and thinner.
Okay, but before we start clocking the minutes, we have to set the scene properly. It's 10:30 at night. Trooper Eichenlaub is on patrol. Now, this matters. Eichenlaub isn't some rookie. He's been with the Pennsylvania State Police since 2017, but more importantly, he's been through desert snow training.
And for anyone who might not be familiar, Desert Snow is a very specialized criminal interdiction program. It essentially teaches officers to look beyond the traffic infraction, to read body language, analyze travel stories, and basically turn a routine speeding ticket into a deep-dive drug investigation. It encourages a very aggressive style of policing.
I would call it proactive policing. So he spots a red 2016 Ford Explorer. He sees it cross the white fog line multiple times. He sees it fail to signal a turn. That is the predicate for the stop. Nobody disputes the stop was legal. The driver, Lenine Confer, pulls over. Eichenlaub approaches. Immediately, the mission of the stop shifts because he detects clear signs of impairment.
Right. Bloodshot eyes, dry mouth, slurred speech. At that moment, this stops being a ticket for a turn signal and becomes a DUI investigation. Legally, that buys the officer time to investigate the driver.
Exactly. And he has to separate the occupants. He has to run field sobriety tests. But while he's doing that, he is also assessing the passenger, Mr. Ernest Coit. And this is where the totality of the circumstances really starts to build.
And this is where the Fourth Amendment draws a line. I mean, the Supreme Court is very clear. A traffic stop can only last as long as necessary to address the violation. If you extend it, you need reasonable suspicion that is specific to the person you are detaining. Cochite wasn't driving. He wasn't slurring his words.
But the stories didn't match. And in the world of interdiction, that is a massive red flag. Eichenlaub separates them. He asks Comfer where they're coming from. She says they went to the old corner to drop off a friend. Then he goes and asks Coat. Coat says they went to the old corner to have a drink.
That is a pretty minor inconsistency, though. Dropping a friend and having a drink aren't mutually exclusive. You could easily do both.
It's not just that, though. Comfort, the driver, tells the trooper she doesn't actually know the passenger's full name. She just calls him E. She thinks he lives in Lock Haven, but she's not sure. She's driving a car that she borrowed with a passenger she can't really name at 10:30 at night. All of that creates a reasonable suspicion that something else is going on.
Suspicious is not a felony. Being vague about your date on a Saturday night isn't a crime. But let's look at what the trooper does with that suspicion. He doesn't just ask questions, he holds them. We have the suppression hearing transcript right here. At the 35-minute and 20-second mark of the body cam video, the defense attorney asks Trooper Eichenlaub a direct question. Was Mr. Coit free to leave?
And he answers no.
He says no. 35 minutes in, the driver has been tested. The trooper is still digging. He's returning to the vehicle drilling Coit again. So why is Coit being held? He is effectively seized without probable cause.
He's being detained for the safety of the scene and because the trooper has reasonable suspicion that criminal activity is afoot, specifically drug trafficking. You're ignoring the Benitez precedent. Commonwealth versus Benitez is the controlling case law in Pennsylvania for this exact scenario.
Well, Benitez is often used as a kind of catch-all justification, but the facts have to align.
And they do. In Benitez, the court ruled that when you have conflicting travel stories, nervous behavior, and, this is key, a criminal history for drug delivery, that creates a blueprint for extending the stop. Eichenlaub ran their IDs. Both Confer and Coit had prior convictions for possession with intent to deliver. So now you have two convicted dealers in a borrowed car with a driver who claims not to know the passenger's name. A reasonable officer does not just say, "Have a nice night," and walk away from that.
But let's talk about the nervousness factor for a second, because Benitez relies so heavily on it. The defense made a very compelling argument about Coit's background during the hearing. Mr. Coit works in entertainment and marketing. It's a high-stress job, and the defense presented evidence that he is a binge user of narcotics, coping with childhood trauma involving an alcoholic father.
That explains the drug use, perhaps.
It explains the nervousness. He is a user sitting in a car with a cop shining a flashlight in his face. Of course he's nervous. He's terrified. When the trooper cites nervous behavior as a reason to hold him for an hour, he's criminalizing a very natural human reaction to being interrogated by an armed agent of the state.
But the officer doesn't know his biography or his trauma history in that moment on the side of the road. He just sees a guy who is shaking, breathing heavy, and, crucially, protecting a green satchel on his lap. And this brings us to the officer's safety component.
The green bag.
Yes, the green satchel. Coit is clutching it. When the trooper asks for his medical marijuana card, Coit unzips the bag just enough to slide the card out. He is actively concealing the contents. Under Terry v. Ohio and reinforced by Commonwealth v. Hernandez, an officer has the right to frisk for weapons if they fear for their safety.
Okay, but Terry allows a pat down for weapons, guns, knives. It does not allow an officer to manipulate a bag to feel for drugs. The trooper testified that he patted down Coit and the bag. Did he feel a gun? No. Did he feel a knife? No. He admitted on the stand he couldn't tell what was behind the bulges.
Which is a terrifying moment for an officer. He feels bulk, he doesn't know what it is.
But that's the standard. If you don't feel a weapon, the search stops. You can't just squeeze and prod until you figure out it's baggies of powder. But Eichenlaub didn't stop. He kept Coit there. And this brings us to the moment where the Commonwealth's case really hits an iceberg. We have to talk about the affidavit of probable cause.
You're referring to the discrepancy in the paperwork.
Calling it a discrepancy is incredibly generous. Let's be precise for the listeners. To get a search warrant or to justify an arrest, an officer has to sign a sworn statement detailing why. In his sworn affidavit, Trooper Eichenlaub wrote that while they were at the scene, on the side of the road, he observed Coit manipulating a plastic bag. He wrote, and I am quoting the document, "The plastic bag was removed from his right pocket that contained two separate plastic baggies with a white powdery substance at the scene."
Right. He wrote that he found the drugs right there on the roadside.
But that never happened. The video proves it never happened. And under cross-examination by the defense attorney, Mr. Johnson, Trooper Eichenlaub admitted it never happened. He didn't find the baggies, he didn't see the white powder, he put the green bag back in the car, had the vehicle towed, and found the drugs later during a warrant search.
I grant you that is a significant error.
It's not an error. It's a fabrication. It is a lie used to establish probable cause retroactively. If he tells the judge, I found cocaine in his pocket, that judge signs the warrant immediately. If he tells the judge, I felt a lump I couldn't identify, so I seized the car to go look for it, well, maybe that judge doesn't sign it.
But he did get a warrant eventually, and he testified that he was doing the best I can with my old notes. Police work is fluid. He wrote the report later. He conflated the timeline. It's sloppy, absolutely. But does a drafting error invalidate the fact that there were 20 grams of cocaine and 136 grams of crystal meth in that bag?
Yes, it absolutely should. The good faith exception doesn't apply if you lie to the magistrate. Doing the best I can with old notes is what you say when you get a date wrong on a parking ticket. It is not what you say when you strip someone of their liberty based on a completely fictional search. This goes to the heart of the judicial process.
But let's look at the inevitable discovery aspect here. Even without that specific sentence in the affidavit, did he have enough to get the warrant? I would argue yes. The defense focuses on the lie to distract from the mountain of other factors. The driver was arrested for DUI. The car had to be towed. Coit couldn't drive it, he didn't own it, and he might have been impaired too. So Coit had to exit the vehicle.
An exit order is standard, sure, but that doesn't authorize a search of his personal effects unless you have probable cause.
Once he exits, the officer has to pat him down before putting him in a cruiser for transport, even just to a gas station. That's just officer safety. And during that pat-down, he feels the large bulges. He sees the deceptive behavior. He knows about the prior delivery convictions. All of that exists outside of the affidavit error. The totality of the circumstances still points to probable cause.
You're reconstructing the probable cause backward. You're saying, well, he would have found it anyway. But the timeline matters. At 1 hour and 22 seconds, Coit is still sitting in that car. The trooper is stalling. He's waiting for a canine unit that isn't coming fast enough, or maybe he's just waiting for Coit to crack. The defense argues that the detention became illegal before the exit order. If the detention was illegal at minute 40, then the exit order at minute 60 is fruit of the poisonous tree. Everything found after that, the bulges, the bag, the meth, it's all inadmissible.
That is a strict reading, but the courts in Pennsylvania have been moving toward a more pragmatic view with Benitez. They look at the mission. The mission here was DUI and safety. Dealing with a passenger who has a known drug history and is acting sketchy is part of securing the scene. The officer has to make these split-second decisions.
But he didn't make a split-second decision. He took an hour, and then he went back to the office and wrote a report that lied about what happened during that hour.
Let's talk about the sheer volume of drugs for a second, because that really anchors the Commonwealth's position. We aren't talking about a user amount here. 136 grams of methamphetamine is not small.
No, it is a lot.
It's massive. That's count 2 of the indictment, plus the 20 grams of cocaine, plus $2,132 in cash. The advocate for the Commonwealth looks at that and says this is trafficking.
And the defense challenges that characterization explicitly. They argue Coit is a bulk buyer. They point to his income. They argue he buys large quantities to avoid frequent transactions, which ironically is a safety measure for a user. He buys enough to binge, stays awake for days, and then he flushes the rest.
That is a very creative narrative. I'm not a dealer. I'm just a very wealthy, very inefficient addict.
It's plausible given the trauma background and the cash. $2,000 is not that much money in 2023. If you're going out for a weekend, maybe buying things, paying rent, having cash isn't a crime. We have to be really careful not to criminalize the possession of currency.
In a vacuum, no. But in a car with baggies of white powder? Come on. The trooper's instincts were right. That's the bottom line. The Desert Snow training works. He saw the signs. He saw the criminal indicators. And if we suppress this evidence because he messed up the paperwork, we are putting 136 grams of meth back on the street.
We are not suppressing it because he messed up. We are suppressing it because the process matters. If we allow instincts to override the Fourth Amendment, then we are all at risk. What if the driver wasn't impaired? What if they were just nervous? Would the trooper still have held them for an hour just because their stories were slightly off?
Probably not. Because the DUI was the anchor. The DUI allowed the time. The inconsistencies filled that time with suspicion. It's a building block approach. The DUI investigation keeps the clock running, and during that time, new suspicion arises about the passenger.
But look at the video evidence again. The defense attorney, Mr. Johnson, notes that the trooper's mic was muted or he was out of earshot for key moments. Then you have the visual of the bag being put back in the car, directly contradicting the written report. It paints a picture of an officer who is manipulating the record to fit the result he got.
Or an officer who's overwhelmed. I mean, we're talking about a highway stop at night. It's dangerous. He's managing 2 suspects alone for a long period of time. It's easy to sit here and judge the paperwork from a comfortable desk. But out there, his priority was safety and securing the evidence.
Then call for backup. Don't invent a search that didn't happen. The reasonable person standard applies to the officer too. Would a reasonable officer sign an affidavit saying, "I saw the drugs," when he didn't? No, that's perjury. And frankly, the inconsistency creates a credibility gap that infects the entire case. If he lied about the search, did he lie about the smell of marijuana? Did he lie about the furtive movements? Once that credibility is cracked, the whole Benitez framework just collapses.
Malice versus mistake. That's what the judge has to weigh. But I want to go back to the Commonwealth v. Hernandez precedent. It establishes that officer safety is paramount. If the trooper felt that leaving Coit with that bag was a risk, even if he couldn't prove it was a weapon, he has some latitude to secure the scene.
Securing the scene is not the same as searching for evidence. You can take the bag away and put it on the hood of the car. You can't open it without a warrant or probable cause. And the trooper knew that. That's why he lied in the affidavit. He knew he didn't have the probable cause to open it at the scene, so he invented a scenario where the drugs were in plain view or came out of the pocket to cure that legal defect. That isn't a mistake. That is a strategy.
That's an assumption of intent that I think goes a little too far. But let's zoom out. What's the takeaway here? For the police, the lesson is clearly fix your paperwork. Don't rely on memory for a felony affidavit. Watch your body cam footage before you write the report. Precision matters.
The lesson for the citizen is you are not free to leave even if they haven't told you why. And the lesson for the legal system is that this totality of the circumstances doctrine is becoming a very dangerous loophole. It allows the courts to sort of squint at a pile of bad police work and say, well, it looks like a crime overall, so we'll allow it.
I see it differently. I see it as the system balancing rights with reality. And the reality is that drug trafficking is messy. It doesn't follow a neat script. If we demand perfection from officers in every single split-second decision, we paralyze them. The courts, through Benitez and Rogers, are saying, we trust the officer's experience. Eichenlaub recognized the pattern. He was right. The discrepancies are unfortunate, but they shouldn't be fatal to the prosecution of a major felony.
But being right about the drugs doesn't make you right about the Constitution. That is the hill I will die on. If the timeline was violated, the evidence is tainted, period. If we accept he was right in the end as a legal standard, we essentially nullify the Fourth Amendment for anyone who actually has something to hide.
And that is why we have suppression hearings, to argue these exact minutes and seconds. It forces the state to justify every single intrusion.
And why we need defense attorneys who actually watch the body cam footage and compare it to the sworn statement. Without that check, without someone catching that discrepancy between the written word and the video reality, this would have just been another plea deal.
A fair point. The system relies on both sides doing their job. In this case, the defense found a crack in the foundation. Whether that crack brings down the whole house, that's up to the judge. But the drugs were real, the history was real, and the stop itself was valid.
It's a fascinating, if troubling, look at just how fragile our rights actually are when you're sitting in the passenger seat of a Ford Explorer at 10:30 at night.
And how complex the job is for the trooper standing outside that window.
We encourage you to dig into the case law. Read Commonwealth versus Benitez, read Rogers. Understanding the rules of engagement on the roadside is something every citizen should do.
Absolutely. Thanks for listening to The Debate.